So as a disclaimer, I remind you again, these are possible theories that may or may not have happened. The only fact that I put before you today is that none of the things said to have come from Becky Hill were things that all of the jurors did not already hear in court before they made their decisions. If we're expected to think that this jury is so weak-minded that a clerk of court repeating what they had already heard in court, or that because they were deprived of a cigarette, they made a foolish, rushed decision after taking their oaths seriously for so many weeks, I find it repulsively insulting. I'm still reserving my decision on what to believe until all of the jurors have made their own statements, not just ones with specific grudges or ones whose words have been put in sworn affidavits by someone else, but all of them in a place far from the influence and intimidation of Dick and Jim, somewhere presided over by a fair judge, where things like leading would not be allowed. Until then, I'm ruminating on all of the possibilities, including Becky Hill overstepping and saying these things, jurors being misquoted, or even intimidated into saying something that didn't actually happen, either through outright pressure or through leading. We simply cannot say at this moment with any amount of certainty which of those situations we're facing. I saw this on Twitter late last night and wanted to share this theory with you too. Is it possible that after all this time has passed, that people's recall is confusing things that happened, perhaps after being led by defense attorneys? Think of how in the protected arena of a courtroom, one of the most common objections you hear is leading the witness, and it's almost always sustained. Why is this against court rules? Because leading a witness can confuse or make someone believe or come to a conclusion that something is so that really isn't so, or make a statement that something is so that really isn't so. Imagine hearing a car come up your driveway, or, as Dick and Jim so insultingly described it, dirt roads.
Myself for spending our weekends on dirt roads in Colleton County.
And looking up to see none other than Dick Harpootlian and Jim Griffin at your door. Not something you expect, since, they're city people who didn't even know such places existed.
And by the way, we've seen more of Colleton County on dirt roads, in places we're city boys, we didn't believe existed in this state.
We've seen places we didn't believe existed in this state. Along with his little snarky laugh. How rude. The people he's relying on to help him win his case, and he's going to scoff at them and describe the places they live as places he didn't know exist in this state. What a piece of work. And here they are, lowering themselves to your level and showing up at your door. Then they come in expressing how other jurors are saying this. Did you see this too? And they also said this and that. Did you feel that way too? It's interesting to me that 2 out of 4 affidavits submitted are submitted by paralegal Holly Miller and not the actual jurors. Will they give their own? Possibly. Were they led to make those statements by 2 larger-than-life men showing up at their humble homes and leading them to do so? I guess we might not ever know that. Here's the thing. The statements they've claimed were said in the courthouse were said in the courthouse, but they were said by Creighton Waters in opening and closing statements.
And as reported under oath by these jurors, it was a direction on how you should receive Alec Murdaugh's testimony. You should look at him. Don't be fooled by him. That subject matter is absolutely material. That's the core of our defense, and that is something that we had no chance to defend against. And so we strongly believe if that evidence is accurate, and the law will require a new trial.
Except for the fact that, as I said, all of these things were presented by Creighton Waters during opening and closing statements, and so you did have a chance to defend against them. This statement is absolutely incorrect. Were they said also in secret behind closed doors? I don't know. We don't know yet. But is it possible that under this kind of I don't want to say coercion because that's such a strong word, but one in this situation caught off guard by these two men might feel somewhat coerced, but most definitely pressured. Here they are grilling you, and they say words you've heard at the courthouse. They're telling you other jurors said Becky said them. You know you heard them. You're nervous. You're under pressure, and bam, false memory is planted. I'm not saying this is for sure what happened. I'm saying this is a very real possibility. The idea that it is allowed for defense attorneys to show up at your door like this is incredible. I can't even imagine what that would feel like. The trial itself was already traumatic. The things they saw and heard, having to decide someone's fate, it's not easy for the average person. They'll never get those images out of their minds. Surely there's even a little PTSD for some. Alex was a huge figure in that area. That was intimidating from the get-go. It was a long trial. So much was said. Now time has passed and we're to trust Dick and Jim with these jurors? I think not. So, is it legal what Dick and Jim did? Perhaps. Is it ethical? Some states and some judges say no. This subject of post-trial interviews is in fact a disputed topic. Not all states allow it, and some states allow it, but with rules attached. For example, in the state of West Virginia, judges from 2 circuits reported that they will consider granting permission for post-trial interviews in special circumstances. But they impose a good cause requirement and application to the court before permission for post-trial communications with jurors will be granted. One judge reportedly will allow post-trial interviews only under court supervision after good cause has been shown. Interviews must be conducted by hearing before the court where the judge and both lawyers have the opportunity to question the jurors. As I mentioned, this protects those jurors from situations such as leading, or the ability from the lawyers to be able to exert pressure on these jurors to say something, which is exactly the reason this judge bases his decision, as it says here, on the inherent power of the court to protect jurors from harassment and undue pressure to change or cast doubt on their verdict. He also stressed the need to impress upon the parties and public that the case is over when the verdict has been reached, and that jurors are not compelled to answer questions nor attempt to explain or justify their verdict without a showing of good cause. In another circuit, permission for post-trial interviews must be sought on a motion to the court, and interviews are permitted only in extraordinary circumstances. In 5 judicial circuits, post-trial interviews are expressly forbidden. This is to protect them from being intruded upon. The NCJ number 121742 puts out this information regarding post-trial interviews with jurors. Post-verdict interviews can be helpful to trial lawyers because they can find out what led the jurors to make the decisions that they made, what things worked, what things didn't work, for them to better their practice. However, this points out that jurors should be interviewed by telephone, also as soon after the verdict as possible, not months later. And now this is very important, by an interviewer who is not one of the attorneys who tried the case. In Florida, the bar has enacted the following rule. A lawyer shall not, after dismissal of the jury in a case which he or she is connected, initiate communication with or cause another to initiate communication with any juror regarding the trial except to determine whether the verdict may be subject to legal challenge. In this case, they may say they felt that. However, it goes on to say, before conducting any such interview, the lawyer must file in the cause a notice of intention to interview, setting forth the name of the juror or jurors to be interviewed. A copy of the notice must be delivered to the trial judge and opposing counsel a reasonable time before such interview. And it goes on to say the court's generally disfavor lawyer contact with jurors after the conclusion of litigation. And it goes on to say, in fact, most jurisdictions have rules which not only prohibit attorneys from interviewing jurors after a trial without the court's permission, but which also strictly limit the scope of any allowed inquiry. And the list goes on in multiple states regarding how to properly carry this out. So we see these regulations established for good reason. Yet we see Dick and Jim driving up on these people, scoffing at the places they live. They speak of getting doors slammed in their faces, so presumably they're coming here uninvited, descending upon the privacy of these jurors' homes. I submit that the way these two carried this out was reckless and inappropriate. And I hope the judge finds this as well. Let's talk about where this started. We have the egg juror. The juror who had expressed her disappointment to Judge Newman about being selected as a juror in a previous trial and the case settled, so she didn't get to serve as a juror. We'll read this directly from court transcript. Judge Newman, you've been on jury duty before? Egg juror, I was. But it kind of really sucked because they called us back and we were, anticipating. It was my first jury. And they made up an agreement. And we never, ever got to sit on the jury. Disappointment. Now, she's landed the role of a juror in the biggest case South Carolina has ever seen, maybe ever will see, probably for sure in her lifetime. And she gets taken out at the last moment. Humiliated. Is she upset? Undoubtedly. Is she salty? Probably. The salty egg juror gets all of this rolling, and once they have her statement, they can use it to leverage other jurors. But in her own words in this court transcript, what did she say at the time it was happening? Judge Newman, so has she, being Becky Hill, discussed this case with any of the jurors? Has the clerk discussed anything about the case with anyone on that jury? Salty egg juror, not that I'm aware of. In her own words, what did she say at the time it was happening? Now, after thinking about it, having to admit to friends and family that she got removed. Hey, weren't you on the jury? Yeah, I got removed. She's embarrassed. She's humiliated. She's angry. Then she sees Becky on her book tour and gets salty. Easy pickings for Dick and Jim. The ball gets rolling. We know how Dick and Jim exaggerate. We know how they grandstand. We know their reputation in that area. They descend upon your home out of the blue and start telling you what other jurors are saying and do all they can to sway you to say it too. Like I said, these are words that they did in fact hear in the courthouse. Let's have a look. On Salty Egg Juror's sworn affidavit, she says, Point 3, she also instructed the jury to watch him closely, look at his actions, and look at his movements. Was that said in court?
Another thing, and this is crucial, what you're going to do in this particular case, is determine credibility or the believability of witnesses. So it would be your job to look at the evidence, the exhibits in the case, but also the witnesses and decide if it's truthful, if you believe it, if you can rely on it. You're going to see video statements of Alec Murdaugh. You're going to see body-worn camera of him at the scene when law enforcement arrives. And hear what he says. And hear what he says about that night. You're going to hear 3 recorded statements on video that he gave with law enforcement, and you're going to hear how things progress about what he says and what he says he did that night. Watch those closely. Watch his expressions. Listen to what he's saying. Listen to what he's not saying. Use that common sense. Does this seem right? Adding more detail, it's just lies. Watch how he responds to this one. Watch what his head does. See if you observe that yourself when he's over there looking you in your eyes and trying to convince you of something.
The next affidavit, I'm really confused why it's even here. First of all, it's not a sworn affidavit by the juror himself, but by the paralegal. He does not confirm hearing Becky tell the jurors not to let defense mislead them. He does say that she indicated that the images that they were going to see would be disturbing. I take issue with that because it's a murder trial. It doesn't matter if the clerk of court has an opinion about guilt or innocence. If there's going to be disturbing images, there's going to be disturbing images, and I don't think that sways either way, because any murder is going to have disturbing images. It doesn't mean you're laying guilt on anyone. It just means the images are going to be disturbing. So if she said that, I don't honestly see the harm in that. Had the jurors, in fact, already been told that in the court? Let's have a look.
You're going to see what he did to Maggie and Paul. It's going to be gruesome. There's no other way around it. It's what he did. You're going to see crime scene photographs. You're going to see the traumatic injuries that were suffered. You're going to hear from a pathologist, a doctor who will examine the injuries. It's going to be gruesome. There's no other way around it.
In fact, in this whole affidavit, again, not signed or taken by the juror himself, the only complaint he had was the smoking complaint. Next, in the affidavit of Juror 630.2, they state, Rebecca Hill told the jury not to be fooled by the evidence presented by Mr. Murdoch's attorneys. The same thought expressed by Juror 785 in point 2, Rebecca Hill told the jurors not to be fooled by the evidence presented to the jury by Mr. Murdoch's attorneys. Had they in fact heard that somewhere else?
This defendant, on the other hand, has fooled everyone who thought they were close to him, everyone who thought they knew he was who he was. He's fooled them all. And he fooled Maggie and Paul too. And they paid for it with their lives. Don't let him fool you too. On behalf of the state of South Carolina, I ask you to return a verdict of guilty.
Could it be that when asked if they were told these things by Becky, a couple recall hearing them but forgot it came from Mr. Waters? Entirely possible. Is it possible Becky repeated these things to them as well? Yes, unfortunately, that's possible too. If she did, are these things actually tampering? Are they damaging enough to cause a retraction of the verdict? Do we really view these jurors as so weak-minded that if she did, it would supersede all rational thought and their ability to make a sound decision? Did these words that had already been said to them in court by Creighton Waters change their minds? Are we going to give them so little credit after all of their hard work? At any rate, we should be hearing from the state soon, and when we do, I will share it with you as always. Until then, this is Cassidy O'Connell saying stay well and stay tuned.